Good morning, everyone, and welcome to the 10th of our KLC breakfast briefings. This one's going to be on employment status. Just before we start, just to let you know that Melanie Whittle, KLC, will be online dealing with the questions that you ask in the chat box. And obviously, if the question is quite complex or if Mel doesn't get around to answering, then you can email in and we'll answer your question for you in that way. Also, just to let you know that Olivia Harris, GoHo, is offering us technical support this morning. And if you have any technical issues, obviously she's your go-to person. So thank you, Liv, and thank you, Mel. Just before we start, just to say that there's going to be a couple of polls in the chat. So please do complete those for us. That would be absolutely marvellous. And then we can gauge what you're wanting to do about certain matters. Before we start, I'm going to remind you, those of you who've been on the Law on Tour will know about it already, but those of you who haven't, just to let you know that we are still taking bookings for our Law on Tour, which we are taking around the country, around the UK in November. These are brilliant one-day seminars, full documentation. I present them with my co-presenter, John Fenton. If you book at the moment, you'll find there's a 20% discount if you're a charity. If there's two or more of you booking, then you'll also get a 20% discount. So do visit our website for the details. If you want to, please give us a call, because some people like talking to human beings, or just email us at klc@klcemploymentlaw.com. Okay, on to the subject of today then, what we're going to be looking at in the next little while. So different types of employment status, the associated rights that go alongside obviously having those particular statuses, the relationship with tax status, we'll just kind of glance on that because there is a relationship that we need just to be aware of. Agency workers, interns and volunteers, how the law views them, and different types of employment contracts, all in 30 minutes, of course, so 30-ish minutes. So I'll get to it. Obviously, as I say, this is a briefing, this is a glance at it, just sort of an overview. And obviously, if you want a deeper dive, then there's other ways of doing that, either come on tour or one of the KLC courses. So there are three general employment statuses. Employees, probably the most, when I say valued, I don't mean as in terms of these people are more valuable to us, but that's the valuable status because it brings with it so many rights and protections. So we have employees, we have workers who have a lot of rights but aren't quite so heavily protected as employees. And then we have our self-employed. And these people actually aren't even defined, explained in statute, but they are people who are in business on their own account. They are responsible for the money they make. In other words, they're responsible for the success of their business. They have total autonomy and they don't have to supply their services personally. So let's just have a little dive into this a little more. Now, the direction of travel has been, I'm sure you're aware, over the last, 5, almost 10 years, for the courts and tribunals, wherever possible, to bestow some sort of employment protection and status onto individuals. So we will have seen the Uber case, Pimlico Plumbers, City Sprint, many, many more, where individuals have been held out by the employer to be robustly self-employed, but the individual has claimed, and generally this is because they want to get the benefit of statutory annual leave, for example, and pay, they will claim that they are workers. And time again, the courts will say, yeah, you've got to really be clear that if you're saying somebody is self-employed, then we expect to see that a business-to-business service. We expect to see lots of aspects of that relationship with regard to maybe the business having many other clients or customers, and there's not going to be that control over the individual. So we know that's the direction of travel. And we know wherever possible, the thoughts are to, as I say, bestow more rights on individuals rather than take them away. And that is, without being political, and that's even kind of under, if you like, a blue government. So it's not, sort of a Labour issue. It's an issue of, I think, just general what is right and proper. Okay, so the definition of an employee in the Employment Rights Act, if you want to look at it, if you're that bored, you can look at section 231, and it describes an employee. It doesn't say much, and this has been the problem with employment status. It just says that it's an individual who has entered into or works under a contract of employment. And then we have a contract of employment defined later as a contract of service or apprenticeship. That's all you get, nothing else. So we've had to rely on case law to fill in those gaps. And that has been a body of case law developed over the years. So what do we know about the filling in of those gaps? First of all, we know that to be an employee, to have the employee status, there has to be what the courts call this irreducible minimum. And the irreducible minimum is that they must perform work personally. That is 99.9% of the time. There are some rare exceptions, but let's flow with this. They must perform work personally. There is mutuality of obligation between the parties. That means that the employee agrees to perform work and to perform it at certain times and on certain days, and to perform certain work. And in response to that, the employer will pay the employee, and there are other rights bestowed, like the overarching duty of care, etc. But it's mutuality of obligation. They agree to be bound in law by this relationship. And then the third aspect is the employer controls the way that the employee undertakes the work. It's not just, here's a vague idea of what you have to do, just rock up, and get it done in some way, shape or form. The employer may control the way that work is done. The employer may control the hours in which the work is done, where the work is done. So there is that element of much more control. Outside of that, those are the things that are absolutely crucial. If the courts and tribunals can't find the irreducible minimum, then the individual can't be an employee. But we need a little bit more. So what else will make somebody look like an employee? Well, there are other factors as well, many factors. So, for example, how well is that individual integrated into the organisation? If you looked at them, could you sort of tell them apart from any other individual? As in, are they treated differently? What is their tax system? Are they taxed as an individual? Are they sort of self-employed tax, or are they actually PAYE? So are they taxed as an employee? And do they receive all the benefits that an employee would expect to receive? So we have, if you like, case law filling in all the gaps that statute has failed miserably to provide. Now, just as another thought here, the government recently sort of tried to sort of restate, these issues of employment status. They didn't really tell us anything new. About 6-7-ish years ago, they were going to, after the Taylor Review, try to define worker, employee, self-employed in much more detail in statute. But the nearest we got was a draft bill, and it looked quite good because it looked like these different statuses were defined in far more detail. Never saw the light of day. So we live with what we have, which is we rely on case law to inform our decisions. So this individual, this employee is hugely protected. Even with short service, as you know, if somebody is dismissed with short service, that's less than 2 years continuous service. If they're dismissed for a range of issues, they can still bring a claim of unfair dismissal, kind of known as automatic unfair dismissal. You won't see that written anywhere in the Employment Rights Act. but they are protected. So, for example, if somebody's dismissed for health and safety matters, or because they wish to join a trade union, or because of their political affiliations, they may claim unfair dismissal even though they haven't got service, and myriad other reasons as well. Okay, so family rights, rights to redundancy, rights to unfair dismissal, which is why it's quite a coveted status. The Employment Rights Act refers to, as you remember, somebody who works under a contract of service or apprenticeship. So let's just have a quick dive into that. Statutory apprenticeships, which is you're probably more familiar with, which is where the individual is effectively an employee. They're working on a training program. The contract has to be for a minimum of a 12-month period, and they do on-the-job training. At least 20% of the working hours are training. As I mentioned, they are employees. Okay, so these are statutory apprenticeships and have become very popular, as opposed to common law apprenticeships, which is what we had before we kind of went into the realms of statutory apprenticeships. Now, common law apprenticeships are quite a different beast altogether. They protect the individual more fully than a statutory apprenticeship, or even more fully, if you like, than any employee. Quite rare. In Scotland, they are the norm because they don't have statutory apprenticeships. Okay, so with this type of person, the individual obviously is being trained. They have more rights, as I mentioned. Even if that individual commits an act of gross misconduct, whereas if you're an employee and you do that, it is likely that you may be dismissed. You can't dismiss a common law apprentice for gross misconduct unless they are untrainable, unless they show them to be, themselves to be untrainable. If there's a redundancy need, you can't just pick those apprentices and say, oh, well, you're selected for redundancy. The only time that common law apprentices can be made redundant is when we'd have a complete closure of the building or the business, should I say. If you try to end the term of this contract before the end of its term, without it being a closure of the business, a redundancy, etc., without the person being untrainable, it will be a breach of contract, and the employer would be liable to pay out the value of the rest of that contract. Okay, all apprentices, they are not covered by the Fixed Term Employees Prevention of Less Favourable Treatment Regulations 2002. So parity doesn't apply, okay? And if an apprentice is terminated, or the contract, shall we say, is ended, sounds better, at the end of the term, that will probably be a dismissal for some other substantial reason. It won't be redundancy, it will be some other substantial reason dismissal. Okay, let's move on to workers. Remember, employees one category, workers, let's say they're kind of second tier down. These individuals are still protected, and their status is defined in the Employment Rights Act at section 233 rather, sometimes known as Limb B workers, because section 233B is of the era, is where they're defined. So they're defined as somebody who's working under a contract of employment, what all employees are, so all workers, all employees are workers, but then the definition goes on to say, or any other contract whereby the individual undertakes to do or perform personally any work or service for another party to the contract whose status is not that of a client or customer. So what this is saying is a worker is somebody who is, well, they might be an employee, or they might be somebody who is working for you under some sort of contract where they have to perform the work personally, but they're not providing that work as a business to business. They're not robustly self-employed, in other words. And this is where a lot of the difficulty and the grey area has arisen, because a lot of people who were held out to be workers really could be considered to be employees because the employer was exerting a lot of control over them. So there was mutuality of obligation. They were performing the work personally. The level of control was such that in some cases, the tribunals and courts will say, well, actually, this person isn't a worker. This person is actually an employee. Okay, so this is somebody who's working under a contract for services as opposed to a contract of service. And remember, if you see LIMBY workers, this is who the reference is being made to. Section 33B of ERA is where we see our definition of a worker. So as I mentioned, in theory, there should be far less control by the employer. In practice, we've seen that doesn't happen. They are likely and should, if they are true LIMBY workers, really be working only for a short period of time shortish period of time with the employer, and may have other work as well. So that would make them look far more like a worker than an employee. They have lots of rights, the same rights of employees, save for these rights. Okay, they can't claim unfair dismissal. They aren't entitled to redundancy pay. Most family rights are really not for them. They do get some family rights, they're agency worker. They aren't entitled to statutory notice. They can't request flexible working. Well, of course they can, but they have no statutory right to. And fixed term contract rights don't apply to workers. They only apply to employees. So there are lots of rights they're entitled to, remember, but these are the rights that they are not entitled to. So what's the problem? When is a worker going to say, well, I'm an employee? Why would they? They might like the flexibility of being a worker and actually going from job to job. Well, what has happened in the past, and the cases we have seen have been where individuals have been held out to be workers, and they've probably been quite happy to be workers because they may, very likely, have been responsible for their own tax, so they haven't been PAYE'd. When the employer has maybe needed to reduce the workforce, well, who am I going to look at first? Well, I'm going to look at my workers first, probably agency workers first, and now look at my workers, because I don't want to have to remove any employees if I don't have to. So where workers have had their contracts terminated because maybe the employer has less work or is contracting, that's when they've said, well, actually, I've been working for you for 5, 6, 7 years continuously. I think I'm an employee, and therefore I think I'm entitled to redundancy pay. And what's more, if you don't give it to me, then I'm going to claim unfair dismissal. I might claim it anyway, because actually you should be putting me in a pool with all the other employees. So that's when we've seen the problems arising. Let's move on to agency workers. Now, agency workers are the workers of the agency. Sometimes agencies employ their workers as employees, but it's very rare. So they are the workers of the agency. They're not the workers of the principal. So if you have agency staff, they won't be your workers, but the law does give them some rights. So in terms of discrimination rights, for example, they are protected under the Equality Act from discrimination from you or any of your other workers or employees. They also have rights under the Agency Worker Regulations 2010. So once they have continuous service of 12 weeks with you, or continuous hire, should I say, then, as you know, they're entitled to parity for basic terms and conditions of employment. So workers, agency workers, are protected in that way. Then we move on to our casual workers. You might know them as bank workers. You might know them as 0 hours contract workers. These are people or individuals who you may have working with you because you have an agreement with them. They might be on a list of workers that you call upon when you need extra cover. Now, these workers have no overarching contract with you, but when they are on assignment with you, so when you call upon them to work. And by the way, the very nature of that agreement will say that they have no obligation to accept work and you have no obligation to offer work. So they've got no mutuality of obligation going on there. So they can't be employees or workers. But when they work for you, when they agree to do that assignment and you agree to pay them for that assignment, they are workers. They are agreeing to work. Unless you have a very kind of loose agreement which says, basically, if you want to walk off halfway through the day, well, you can, because there's no mutuality of obligation. That is, that was, if you heard that sound, that was the train going past. We're quite near the station here. So during the assignment, they have mutuality of obligation. After the assignment, that's it. There's no overarching contract. Okay, and that's how that works. While they are with you as a worker, during that assignment, of course, they're entitled to the rights that workers get, which is why they're entitled to SSP and statutory annual leave, etc. Okay, let's move on to volunteers and interns. Now, volunteers first. Volunteers are not workers. This has been tested in the courts, right up to the Court of Appeal. They have no legal status. They are people who just volunteer to work. They don't have to for you, and you don't have to let them work for you. They're volunteers, no rights at all, other than obviously, the duty of care that you would have with regard to their health and safety, but that's where it ends. Now, when it comes to interns, that's where things get a little bit more tricky. And over the years, this status has been, I guess, abused by some employers. So we'll call you an intern, we'll make you work really hard doing lots of things, but we won't pay you anything because you're an intern. Now, lots of those situations have turned into cases where the individual has been entitled to worker status and obviously national minimum wage and all the other rights that go along with being a worker. Now, if an intern is a work placement, so it might be part of their higher education placement and they are doing some work, generally shadowing, then that will be fine. They may be not paid. If somebody's just coming into your organisation as an intern and they are literally shadowing, being mentored by a more experienced individual, again, they don't have to be paid because they're there purely for their benefit of training. And that's really the acid test here. If you're getting lots of benefit out of it, it's unlikely that they're going to be looking like a true intern. Okay, moving on then, the self-employed. Not defined at all in statute. As I mentioned, in the draft bill ages ago, they did define self-employed people. That was quite helpful, but there is no definition in ERA. But what we do know is this is somebody who is robustly self-employed. They're in business on their own account. They are providing a service, business to business. They don't have to provide that personally. They might go along and have a discussion with the client about a project, an assignment, some work that needs doing, and then they will assign one of their employees or workers to carry out that work. Generally speaking, they have no employment rights at all. But just caveat to that, you may have read the case about Ellison Bailey, the barrister who brought claims against her Chambers and Stonewall for discrimination. Well, barristers are self-employed, we know that. So how could Ellison Bailey bring a claim? That is because chambers are considered to be unincorporated associations, which obviously means that the individual is protected under the Equality Act. Okay, so that's how she was able to bring her claim. By the way, she won her claim against the chambers. She lost the claim against Stonewall. So it's quite a complicated matter. What else do we want to touch on here? Yeah, let's just quickly talk about IR35. Now, I've talked about workers and that some workers are self-employed and therefore they are responsible for their own tax. A lot of individuals, and this kind of started a while back now, started presenting themselves behind their own private services company, generally speaking, a limited company. And over 20 years ago, the IR35 tax rules were introduced to prevent individuals from basically, setting themselves up and then circumventing the tax system. In other words, people who should be PAYE'd and were not being PAYE'd. Now, as you know, IR35 rules have been reformed, and it now means that the end user is responsible for the determination of whether the individual falls within the IR35 tax rules or out with the tax rules. And obviously, if the end user gets it wrong, then they would be responsible for any shortfall in tax. Before the reform, it was the individual who would be responsible for an incorrect determination of IR35 status. So if somebody is robustly self-employed, if they are working for lots of other people, they're working on a schedule of works, they're sort of being paid for what they deliver, then they might be outside IR35. But if they look like an employee, then they're going to be taxed as an employee. However, the important point here is to say is just because they're taxed as an employee, they're PAYE'd, doesn't mean to say they automatically get a status of being an employee, because they don't. It's a bit of a strange situation. When we look at tax and employment status, so these are two separate matters, and the tests, though similar, are separate tests. For employment status, as I've mentioned, there's broadly three employment statuses. When we look at tax, there's only two. So you're either employed for tax purposes, PAYE, or you're self-employed. So as you can see, there's already, if you like, an anomaly, three types of employment status, only two tax statuses. It's difficult to get to grips with. Okay, as I mentioned, being considered an employee, if you like, for tax purposes, doesn't necessarily give you the status of being an employee for employment purposes, and vice versa. Okay, a little bit about part-time workers, different types of contracts. I mentioned I talk about that. There are regulations, as you know, to protect part-time workers. They apply to workers and employees, and obviously, as you know, no less favourable treatment must be afforded to people on part-time contracts. Sometimes it is objectively justifiable, but in most circumstances, proration is what we are absolutely used to now. And then we come on to our temporary contracts. Temporary contract is different to a fixed term contract. We don't see them very much these days, but it's where we have a start date but no finish date. Neither is there anything which actually says when somebody returns to work, this contract will end. It has no end determination, and so it's not really that attractive. Come and work for us from tomorrow. We don't know really how long it's going to be. Could be about, I don't know really, but come and work for us. It's not something that is terribly attractive. What we tend to see is a fixed term contract. Fixed term contracts, as I mentioned, just apply to employees, not workers. And they have a start date and an end date. It's easy. 1st of January ends 31st of December. Or the contract will end when the job holder returns to work from maternity leave or from sick leave. By performance, that occurrence will end the contract. No less favourable treatment must be afforded, but what we can do is do a quid pro quo. We can actually give you sort of, another benefit in lieu of something which is quite difficult to give you. In other words, your kind of value of your employment package is the same as somebody who's a permanent worker. And in very rare circumstances, we can justify not giving that benefit to you at all. The same statutory rights apply to fixed-term contract employees as they do permanent employees. Obviously, to get certain rights, we need to accrue certain service, but the same rules apply about automatic unfair dismissal, etc. Now, the end or the non-renewal of a fixed-term contract is a dismissal at law. You'll be aware of this. So we have to make sure that we've observed all the niceties of Section 98 era, the piece that talks about unfair dismissal. So we have to know why we are not renewing that contract. It has to be for a potentially fair reason. And obviously, we have to do that in a fair way. If we're terminating now, if the person has 2 years service, they have the right to bring a claim of ordinary unfair dismissal. They have less than 2 years service, they still are protected for a claim of, if you like, automatic unfair dismissal. So we have to be careful why we're not renewing this contract. And again, as you probably know, if we keep that person on our books and we renew the contract without any gaps in service, if we take them over 4 years, their contract becomes permanent by operation of law. Okay, that's all I'm going to say today. Just a few things before you go. Your questions, if you haven't managed to sort of get them in the chat box, or Melanie hasn't managed to answer them, then do email us at klc@klcemploymentlaw.com and we'll get back to you with your answer about today's matter. And just to remind you about the poll that we're running, you can answer those questions, and also to remind you about the autumn law, and to click on our website, have a look, see where the tour's going. If you want any information, just give us a call or email us and we can let you know. Thank you very much for joining me this morning. I hope you've enjoyed the briefing. Number 11, not quite sure that will be about yet, but we will have a number 11 briefing. In the meantime, we'll have a new Prime Minister, I think, in a few hours. Let's see how we go with that. Let's wish that person well for all our sakes, and have a good day, and I'll see you on the next briefing, if not sooner. Goodbye for now.